Good afternoon, ladies and gentlemen. My name is Emanuilov, and I'm a senior researcher at the Center for IT and IP Law at the KU Leuven as law faculty. And today I'm going to present a short presentation on the new legal framework on drone regulation in the EU. The purpose of this presentation is to set up the scene so that we can discuss more during our online meeting in a couple of weeks. So, as you may remember from our previous meetings, a lot has happened in the past couple of years in the EU when it comes to the regulation of drones. And the outline of my presentation basically focuses on three main aspects. The first being a short introduction into the new EU legal framework on civil aviation safety, which is the basic regulation. Then highlighting the delegated and implementing regulations on unmanned aircraft systems operations, as they are called. These are quite detailed regulations, and we'll see some of these details. And then finally, the new rules in Belgium, which were adopted only a couple of months ago in November. So, where are we now? As you can see, and as I said already, a lot has happened. In 2021, we are looking mainly at where to go forward with the so-called standard scenarios, and I'll come to that a bit later, how to deal with use-based regulation and what to do with the certification specifications for the certified category. Now, that's probably not of such great interest to you. I mean, the first 2 points, probably the third, I guess not so much, because the operations you would likely be considering do not involve certified category operations. And then we have, of course, as I said, the Belgian regulation, the royal decree that was adopted pursuant to some of the provisions of the 947 to 2019 regulation of the Commission. Now, I have to say, and I guess that's no secret to you, that the COVID-19 pandemic had significant impact and is still having significant impact on the whole aviation industry, and drone flights make no exception to that. As you will see, some of the deadlines, even the date of application of the regulations was postponed in order to reflect the need for operators and remote pilots to comply with these rules, given the difficulties, obviously, in complying with these rules amidst a global pandemic. So, the new legal framework on civil aviation safety, as I said, this is basically a set of rules concentrated in Regulation 2018-1139, which sets out common rules in the field of civil aviation. The regulation was published in September 2018, and to be frank, this is a regulation that goes far beyond drone operations. It basically regulates the whole of European aviation, and it is, in this sense, a very detailed instrument. I'm not going to go into details as to all of its specifics. You can, of course, take a look at the slides, and if you have any questions, you could, of course, raise them during our meeting. Now, an important thing to note is that, of course, the rule has changed, meaning that it's no longer the case that unmanned aircraft with a maximum takeoff mass of less than 150 kilograms are subject to national law. That was the case before. That's not the case anymore, and the Commission has adopted these implementing and delegated regulation pursuant to Article 58 and 57 of the basic regulation, which gives it a mandate to regulate UAS operations in their entirety. And here you can see a conceptual map of the basic regulation, which was prepared by a colleague from Eurocontrol, to see how detailed it aims to be. Also, in terms of regulation of unmanned aircraft, there is a specific section in Chapter 3, substantive requirements of the regulation. which then goes, as you can see here, into essential requirements, compliance, implementing acts, and delegated powers. So the basic regulation sets out the ground, and then the implementing and delegated rules deal with the details. Now, this regulation applies to the design, production, maintenance, and operation of aircraft. And there are, of course, where the aircraft is or will be registered in a member state, so that's pursuant to the Chicago Convention in its Article 83 bis. Whether it's registered in a third country and operated by an aircraft operator established, residing, or with a particular place of business in the territory to which the treaties apply. And then finally, an unmanned aircraft that is registered neither in a member state nor in a third country, and that is operated within the territory to which the treaties apply by an aircraft operator which is established, residing, or with a principal place of business within that territory. So you can see that the jurisdiction of this regulation is quite broad, and it aims to capture all use cases that might have a tangible connection to the territory to which the fundamental treaties of the EU apply. The regulation, however, does not apply to basically what we call state aviation, namely aircraft carrying military, customs, police, search and rescue, firefighting, border control, coast guard, or similar activities and services undertaken in the public interest. And this is also reflected in the Belgian regulation that was adopted. Of course, this is subject to state sovereignty, so it's within the scope and mandate of nation states to adopt and govern these activities. Now, as I said, the European Commission now has the powers to adopt implementing regulations and delegated regulations for design, production, and maintenance of any type of unmanned aircraft system. So this is a significant novelty, and regulations may also introduce requirements for certification or declaration of compliance. Now, this is different from type certification. It's something to remember. And also Annex 9 to the basic regulation sets out essential requirements for unmanned aircraft systems. And it's the starting point for design, production, maintenance, and operations. Now, there are also generic requirements applicable to all types of unmanned aircraft systems, and more detailed requirements that depend on the classes that are subject to certification or declaration. Now, that brings me to the point of discussing the actual content of these new delegated and implementing regulations. And I assume that a lot of you are familiar with them, but I'll try to be brief and only give you the highlights of these points. So, the delegated regulation deals with unmanned aircraft systems and third country operators of unmanned aircraft systems. And this regulation was complemented by an amending delegated regulation of 2020, and it concerns the introduction of two new unmanned aircraft systems classes. That's not so important here, so I'm not going to focus on this more. Importantly, however, the implementing regulation, which sets out the rules and procedures for the operation of unmanned aircraft, it changed some things with respect to the COVID-19 pandemic, mainly, as you can see in the title, postponing dates of application of certain measures, and I'll come back to that in a moment. And there was also a new regulation of May last year, which was an amending regulation again, concerning standard scenarios for operations executed in or beyond the visual line of sight. Some of you may remember this was on the agenda of the Commission for quite some time, and these are basically the first two standard scenarios adopted and approved at the level of the European Union. Now, In addition to all this, there are, of course, the so-called acceptable means of compliance and guidance material, which are in per se not binding on operators or other stakeholders, but which have a very significant persuasive role because they have been adopted after considerable discussions and debate within the European Union Aviation Safety Agency. Now, what is the role of these implementing and delegated regulations? Well, basically, they establish three categories of operations, namely open, specific, and certified. They focus on open and specific categories, and manned aircraft regulations are expected to be amended for the certified category. That has not yet happened, but it's still something very high on the agenda. And there are details in the annex on UAS operations in the open and specific categories, and in the delegated regulation which prescribe product criteria for unmanned aircraft systems for open category use, limits the marketing of such systems not meeting these criteria, and so on. So these are very detailed annexes, and I would advise you to check them out to get an idea of how detailed they go. Now, there are certain guiding principles in this implementing regulation and the rules and procedures for the operation of unmanned aircraft, namely proportionality, the nature of operation and activity, the risk of operation, the operational characteristics of unmanned aircraft, and the characteristics of area of operation, such as population density, surface characteristics, buildings, and so on. So you can see the evolution from the previous framework where the main criteria was the maximum takeoff mass. Now we focus not only on a risk-based approach, but also on measures that are proportionate to the nature of operation and activity and to the characteristics of the aircraft and, of course, the area within which you'd be operating. Obviously, it's not the same if you're in a densely populated city area or high in the mountains where there may be no one there who might potentially be injured by any adverse consequences of these operations. Now, the implementing regulation sets out, as I said, three categories. First one is the open category that's not subject to any prior operational authorization, nor to an operational declaration by the operator. It's limited to aircraft with a maximum takeoff mass of less than 25 kilograms and height above ground level of less than 120 meters. You cannot overfly assemblies of people within this category of operations, and also you are not allowed to conduct autonomous operations, which are in principle allowed under the new operations, but not for the open category, where the remote pilot is required to be able to take control at any given moment. Now, in the specific category, there is a requirement for an operational authorization, which is issued by a competent authority in member states or where the operator is registered, or alternatively a declaration for an operation which complies with a standard scenario. So you have a standard scenario, you decide that your operation fits within its parameters, and then you submit a declaration whereby you say, okay, I am complying with this standard scenario. And this category also requires certain risk assessment and mitigation measures, especially where you're submitting an application for operational authorization. There is also the certified category where certification takes place pursuant to delegated regulation of operator, licensing of remote pilot, and so on. And this concerns major operations, large-scale operations over assemblies of people, transport of people, carriage of dangerous goods, which may result in high risk for third parties in case of an accident, and so on. So you can compare this to the risk posed by civil aviation at large. I mean, commercial civil aviation with jetliners. So the open category is mainly regulated in Article 3A and 4 of the implementing regulation, and also Part A of the annex. It's divided into 3 operational subcategories, A1 to A3, and 5 platform classes from C0 to C4, which is also linked to the takeoff mass of the aircraft itself. As I mentioned, the limitations are that you're only allowed to take the visual line of sight operations. The maximum takeoff mass can be 25 kilograms and the maximum altitude of 120 meters above ground level, except if you're flying over a fixed obstacle over 70 meters. Now, limited flight over involved people and prohibition of flights above open air assemblies of people is also another limitation. And these aircraft must meet the criteria of C0 or C4 or be privately built, and that's detailed in the regulation. There are also certain competence requirements, and importantly, the responsibility always lies with the operator and the remote pilot. And the remote pilot must always be able to take control. So fully autonomous operations are prohibited. You may ask, are all autonomous operations prohibited? Perhaps no, because this ability to take control implies that you may not be in control at any given moment, but you should in any case be able to take back the control at any given moment. So perhaps partly autonomous or operations supported by autonomous technology would still be allowed within the open category. Now, concerning the specific category, the regulation is in Article 3b and 5 of the implementing regulation, and it concerns any operation which does not meet any of the operational requirements of the open category. So in this case, you must obtain an operational authorization, or you must submit a declaration of compliance with the standard scenario, or you could also apply for a light UAS operator certificate, whereby certain privileges and operational limitations for the operator are designed. So it's basically like a license to operate. Now, I mentioned the 2 new standard scenarios developed by EASA and adopted within the regulation. You could take a look at them. I'm not going to focus that much, and we can discuss them during the meeting. Authorization in these cases is issued by the state of principal place of business or residence. For EU operators, operations in other EU member states are subject to check by the competent authority of compliance with procedures, and in Belgium that's the GTA. For non-EU operators, authorization is needed from each member state where operations will take place. And in this case, in the specific category, autonomous operations are allowed subject to certain conditions to guarantee safety and minimum separations. These conditions are detailed in the annex. The operational risk assessment that I mentioned, it is basically a 5-step procedure. So first you must describe the characteristics of the operation, propose adequate safety objectives, identify risks of the operation not only in the air but also on the ground. You must identify a range of possible risk mitigating measures, and you must determine the level of robustness of the selected mitigating measures. Now, the JARUS guidelines on specific operations risk assessment have been adopted, so some of you are probably familiar with them. It's a significant effort, and I believe one that would be of great help to operators and authorities alike. Now, concerning cross-border operations and operations outside the state of registration, in these cases, the regulation provides that the operator must provide the competent authority of the member state of intended operation with an application, and this application must contain a copy of the operational authorization granted to the operator first, and second, the locations of intended operations, including updated mitigation measures if such are needed, which may be necessary to address risks which are specific to the local airspace, terrain, population characteristics, or even climate conditions. So this shows you the proportionate nature of and risk-based nature of the regulation. And there must also be communication between authorities. The regulation tries to handle this. Upon receipt of the application, the competent authority of a member state of intended operation assesses it without delay. And the competent authority of the member state of registration in the UAS operates must be provided with a confirmation. Now, as you may know, these regulations is still a new registration system. So now member states have an obligation to establish and maintain accurate registration systems for UAS and the obligation to operators to register. So this obligation is triggered in the open category when an aircraft has a maximum takeoff mass of more than 250 grams, or which in the case of an impact can transfer to a human kinetic energy above 80 joules. Equipped with a sensor able to capture with personal data, if you have that, which is basically any commercially available camera today, you would again be within the scope of registration requirements. And for the specific category operations, that's always mandatory. Now, there is only one registration and only in the member state where you have your residence for natural persons, if you're a natural person, or where you have your principal place of business if you're a legal person. So that means you only register in Belgium. You don't need to register in all EU member states, even if you're planning to operate there. The criteria for registration and the design is subject to certification, and the UAS operators whose operation may present certain risks to safety, security, privacy, and personal data protection or environment are all required to register. Now, the obligation to ensure interoperability of registration systems lies with member states, and this obligation has been postponed in time in light of the COVID-19 pandemic. It's one of the obligations that was postponed last year. Another important and interesting point is the operational conditions for geographical zones. So member states may define so-called UAS geographical zones, and this may be for safety, security, privacy, or environmental reasons. And the scope of action here is that they may prohibit certain or all operations. They may request conditions for certain or all operations, or they may request a prior operational authorizations for certain or all operations. Furthermore, within such zones, operations may be subjected to specific environmental standards, and certain classes of aircraft may be allowed, or access may be allowed only to aircraft equipped with certain technical features such as remote identification or geo-awareness system. So this is all within the mandate of member states to adopt when they designate a geographical zone. So we'll see in a few moments how that's set up in Belgium, for example. Now, in terms of existing authorizations, declarations, and certificates in other member states, and in Belgium, of course, authorizations granted to US operators, certificates of remote pilot competency, and declarations that have been made by operators or equivalent documentation that's been issued on the basis of national law. So in the case of Belgium, on the basis of the 2016 Royal Decree. These will remain valid, and for initially that was the goal to remain valid until 1st of July 2021, but now with the COVID-19 pandemic, that's been postponed until 1st of January 2022. So you basically have member states have a year or so whereby they may maintain the validity of these documents. The regulation itself applies from the 31st of December 2020, so it's already applicable throughout the EU. Initially that was until 1st of July, but again it was postponed. And paragraph 3 of Article 15 applies from the 1st of January 2022. Now this paragraph refers to the definition of such geographical zones for geo-awareness purposes, and in this case member states must ensure that the information on these zones, including for how long they are valid, is made publicly available in a common unique digital format. So they've been given more time to sort out the issues around this interoperability with other member states. The delegated regulation itself, it deals with, as I said, requirements for the design and manufacture of such aircraft, conditions, certain conditions defined in implementing regulations and remote identification add-ons. In this regulation, you will also see that the type of aircraft whose design, production, and maintenance shall be subject to certification are defined, and more rules are established on making such aircraft intended for use in the open category and remote identification add-ons available on the market and their free movement in the EU. And finally, there are also some rules for third country operators when they conduct an operation pursuant to the implementing regulation within the airspace of the single European sky. Now, I mentioned standard scenarios a couple of times, and I will just give you a brief idea of what these are. So, the idea of standard scenarios is to ensure that emerging safety issues are addressed. And they incorporate improvements that result from relevant developments in new technologies and from the application of the implemented and delegated act to these situations. But standard scenarios are mostly developed for those operations in a specific category that are considered mature enough based on a declaration. So we more or less know that certain operations are typical and they developed in a certain way. So when that's the case, there are certain common elements between these operations, and that allows for the development of standard scenarios. And that's also the reason behind the adoption of these two standard scenarios at EU level. These two standard scenarios that were included in the opinion were actually derived from the in-service experience gained in some member states, and that's how they made their place into the regulation. In some of these member states, such operations were subject to an operation declaration, or were even conducted without the need of a declaration. So they were related to these. So you can see that in this case, you have visual line of sight operations at a maximum height of 120 meters at a ground speed of less than 5 meters per second. In the case of untethered UA, over controlled ground areas that can be in populated environments using aircraft with maximum takeoff masses of up to 25 kilograms. So it's a very specific standard scenario. That's the first one. And the second one is for beyond visual line of sight operations with the aircraft at not more than 2 kilometers, however, from the remote pilot, if visual observers are used at a maximum height of 120 meters over controlled ground areas in sparsely populated environments using aircraft with maximum takeoff mass of, again, up to 25 kilograms. So it's not the most ambitious of standard scenarios, but it certainly covers a lot of operations that so far have required many additional actions from operators in many member states. So that brings me to the question also of airspace access and how do we deal with managing all this traffic that is, that will hopefully emerge in the coming years in our airspace. So that's what the proposed use space legal framework aims to deal with. I say proposed because no regulation has been adopted so far, and it will probably take again some time to get there. But the ambition with use space, so-called use space, is to create a single drone and use space services market. So the idea is to have a single competitive market throughout the EU, taking the operator's perspective, segregating air traffic management and use space, so as not to overburden the existing ATM system, which prior to the pandemic was quite heavy loaded. To deal in a phased approach with safety, to be basically a plug and play system, really a machine to machine system, so largely depending on communication between devices. To comply with automated flight rules, standard equipment, and of course a system that takes into account the societal concerns of having a heavily populated sky with a buzzing noise coming from here and there, so to say, not to mention, of course, the privacy and environmental protection concerns. Now, USpace is designed technically as a data-driven digital system, and with the goal to deliver a set of automated functions, services, and procedures to ensure the safe, secure, sustainable, and sufficient aircraft operations in a specific volume of airspace. It's planned as a digital system, providing certain services and procedures linked to the type of operation, and they are designed or should be designed to evolve in time, and provision of airspace to be designated. So the use-based regulation is, in a way, a natural development of the traditional aviation regulations, which are based on the interaction between a pilot and an air traffic controller. But they are inspired not only by rules of air law, but also by other sectoral legislation. And in this, they differ. So they take inspiration from ICT, from telecoms law, from privacy law, and so on. The principle of use space as such is that state sovereignty over airspace remains. So we're not talking about taking the sovereignty away from states, no. Local authorities would be heavily involved to manage societal concerns at local level. And there should be a list of basic services common in the EU space that are key requisites for certification, oversight, and enforcement. It should be complementary with air traffic management, so they are not mutually exclusive, quite the opposite, they complement each other. There should also be effective exchange and free flow of data between ATM and USpace, and certification of USpace service providers should be considered by this regulation. And there should also be specific rules of the air for you flights. So we are not going to stick to the rules of the air that we have in the Chicago Convention necessarily. I mean, obviously some of them will be the basis, but we need to have also specific rules for you flights. The system would be accessible based on the user pays principle, and it should be established, and that's new, because you know that ATM is typically natural monopoly, is in a natural monopoly position in member states, so the state decides how to do it and whether to, and what principles to adopt. Now, with USpace, the idea is to have a market based on free competition between USpace service providers in the same volume of airspace, and that's a novelty. That's very interesting to see how it will evolve. Now, last year, EASA published its opinion outlining certain regulatory principles of fair and equal access to airspace, of a risk-based approach, of accommodating initial beyond visual line of sight operations in the short term, and of fostering further development of the implementation architectures and services of USpace. This opinion contained also a proposal for regulation, a high-level regulation for USpace. To the best of my knowledge, this has not yet made it to the European Commission, or at least they haven't voiced any public opinion on how this could be shaped. But here you can see that was in the previous draft opinion. For whatever reason, it didn't make it into the final opinion, but this scheme shows you the technical architecture of the of USpace and how it was envisioned as a platform, a common information function that is shared with authorities, air navigation service providers, air traffic service providers, and so on. And of course, the operators and USpace service providers. So that's how you. That's how the market for different USpace service providers is envisioned to be, and you can also see the role played by telecoms, IT service providers, and infrastructure service providers, of course. Now, if you look at the draft regulation, you would see that there are certain 4 mandatory services, so to say, and 3 additional services. So what the regulation foresees as mandatory services is network identification, geo-awareness, traffic information, and flight authorization. And I guess it only makes sense for a largely and highly autonomous and automated system that U-Space would be. Additional services might be tracking services, weather information services, and performance monitoring services. It is expected that as U-Space develops in the coming years, probably more services will emerge, and there might also be a market for services within the U-Space system. Now that brings me to the final point of this presentation, namely the Belgian legal framework. Now, this instrument was adopted on the 8th of November last year, and pursuant to this royal decree, the DGTA is designated as a competent authority, as referred to in Article 17 of the implementing regulation. Interestingly, the instrument provides very detailed provisions on data protection concerning the registers that member states have to maintain. So in this case, it's very clearly stated in the law that the DGTA is considered a data controller. The regulation also focuses on the establishment of geographical zones. And here it's interesting that public authorities and legal persons can make requests for the establishment of such zones. So if you believe that a zone should be established somewhere in Belgium, you could approach the DGTA and say, okay, I would like to request the establishment of such a zone, and you need to justify the interest to be protected. So these may be no-fly zones or to the contrary zones where you have certain relaxation of rules, for example. There is also an exception in case of emergency. Of course, it's only natural, and in this case, this is done through notice to airmen, NOTAM. The regulation also establishes a minimum age for remote pilots in the open category, specifically for subcategories A1 and A3, that's 14 years. For subcategory A2, that's 16 years. And it also prescribes that mandatory civil insurance for third-party damages in the open category should be taken by anyone operating an aircraft with a maximum takeoff mass of more or equal to 20 kilograms. That's below 20 kilograms. For operators that operate aircraft with a maximum takeoff mass of more or equal to 20 kilograms, the insurance should be issued under Regulation 785/2004, and that's basically the regulation applicable to all civil commercial aviation operators. So this is the so-called hardcore insurance regime, and this regime is also applicable when it comes to, and mandatory when it comes to, the specific category operations. So you can see that insurance and liability issues have been taken quite seriously by the regulation. Now, something that will probably be of interest to you, the so-called transition to the European system. How's that going to happen? Well, the regulation, the Royal Decree prescribes that a remote pilot which holds a valid remote pilot certificate issued in accordance with the Royal Decree of 2016 shall obtain proof of having completed the training online, referred to in Part A of the Annex to the 947 regulations, if he or she follows the training and passes the online theoretical examination relating only to the regulation 947, which is organized by the DGTA. Furthermore, a remote pilot who holds a valid remote pilot license issued again in accordance with the Royal Decree of 2016, who has completed the training and successfully completed the online theoretical examination shall obtain a proof of completion of such training and a certificate of competency as a remote pilot. So these are the conditions to basically relicense. The Director General shall determine, on the basis again of acceptable means of compliance published by the European Aviation Safety Agency, the detailed content of the online training and the questions of the theoretical examination online. That, as far as I know, has not yet been done. the Director General also determines the procedures relating to the practical organization of this online training and the exam, particularly measures to ensure, of course, the integrity of examinations, procedures concerning the verification of the candidate's identity, and so on. It's all taking place online, as you can see. And then the candidate is deemed to have passed the online theoretical examination if they obtain at least 75% of the correct answers. The regulation specifically points that remote pilot certificates, remote pilot licenses, Class 1B declarations and 1A authorizations and documents that are attached to them shall remain valid until their expiry date, or at the latest until January the 1st, 2022, which is the deadline set out in the implementing regulation, of course. And Minister can also define national standard scenarios, which is something interesting, and I guess that there would be further work in Belgium as to how to specify such national standard scenarios. What are the most typical operations? And I guess that you, as stakeholders of the OmniDrone project, would also have ideas as to what potential national scenarios might be of use to you and might make your use and your UAS operations easier. Not only, of course, in Belgium, also internationally, I guess, and the regulation does not prohibit that to have standard scenarios across member states. So, for example, if you know that you have cross-border operations on a regular basis with the Netherlands, then it only makes sense to have such a standard scenario adopted by both countries. And of course, if it's something bigger, then this could also go and be considered at the EU level by the Commission and EASA as a EU-wide standard scenario. Now, this regulation also gives a very special, prominent role of the Belgian Civil Drone Council. It's recognized officially as an advisory body dedicated to the professional drone sector in Belgium. It's made up of representatives of public administrations and members from the Belgian professional drone sector. It's based on a membership request made by the candidate. This advisory board may formulate proposals or recommendations which are not binding, but which are expected to have a very persuasive role, so to say. And finally, the 2060 Royal Decree is now officially repealed as of the moment of entry into force of the new decree, which was 31st of December 2020. So you can officially consider the Royal Decree of 2060 repealed now. So let's look at what a new framework has to bring us. Thanks a lot for your attention, and I look forward to the discussion during our meeting and your questions, of course. Thank you.